Hello everyone, good afternoon and welcome to today's webinar from Wolfsdorf Rosenthal LLP. My name is Joseph Shepard and I'm going to walk you through the latest developments in immigration and nationality law in the U.S. as it pertains to LGBT foreign nationals and their families. In particular, I'm going to focus on the latest developments and some of the hot topics that have occurred recently. Before I get started, I just want to also let you know that if you have any questions, you can use your chat feature if you're visiting us through the GoToWebinar function. Thank you all for attending, and let's get started. So, in a nutshell, before the Defense of Marriage Act was repealed last summer, specifically the section relating to the federal recognition of marriage benefits, the rule, as it had been, was the place of celebration rule. That is, the marriage would be recognized if it was valid where performed, meaning that the jurisdiction in which the marriage takes place is legally bound by and able to issue and confer that marriage certificate, that it was not done in bad faith, and it was not contrary to strong public policy considerations, quote unquote, in the state where the couple resides or intends to reside. That had been a question prior to the fall of DOMA as to whether or not it would matter, specifically things like many state Defense of Marriage Acts or many state bans, constitutional or passed by law, from recognizing marriages. We learned after the fact, and I'll get into these in more detail later, that Obama's administration's policy was an immediate recognition of, for federal purposes, of all validly performed and not in bad faith marriages, regardless of the domicile, where they reside, or where the couple intends to reside in the U.S., which is great news. So, where are we now? Well, we are exactly where we thought. Same-sex couples who are married are now treated just like opposite-sex couples who are married, as long as they are married. If you're married, you're married, which is great news for foreign nationals who, for decades or even just recently, have been separated or facing major complications from being with their loved one here in the U.S. There was also a precedent BIA decision on point called Matter of Zeleniak. Pardon this. I'm going to say this. There's a precedent BIA decision putting out this rule. So if those who are interested want to look up that citation, that is the one on point. You can find a free copy of that on the Department of Justice's website. You can do a search for that citation and it will likely come up. Otherwise, you can email me afterwards and I can send it to you. So, this topic is LGBT immigration for foreign nationals, and transgender marriages. Individuals who are transgender who are married to someone, regardless of the gender of the other person. It's the same. The rule is exactly the same as long as the marriage was valid where performed, not in bad faith and not contrary to any public policy considerations, strong enough to say that the marriage can't be recognized, and we already know that same-sex marriage bans or even marriage laws relating to transgender marriages are not strong enough public policy considerations to override this recognition. Just for your knowledge and background, things that would amount to this strong enough public policy consideration for each state or jurisdiction would be things that would make the marriage criminal. For example, incest would be criminal. You cannot marry an immediate relative. Those kinds of things strongly frowned upon and not recognized if the state has a strong public policy consideration against it. That is where they reside. Also note, for immigration purposes, this means overall that marriage is a gender-neutral institution for immigration purposes now. In general, it does not matter what gender or sex the person that you marry is, as long as you were able to or will be able to legally marry them in the jurisdiction where you did or intend to get married. This also means that for individuals who are transgender, sexual reassignment surgery is not required for immigration purposes. There are some specific requirements that do have to be met in order to obtain a identity document or identification card, for example, a visa or a green card or a EAD card issued in the new or changed gender. Those specific considerations are outside the scope of this general presentation, but I can just briefly tell you that a doctor's letter, a certain kind of doctor's letter, that specifies that all necessary medical steps have been taken to effectuate the change in gender, together with other types of evidence like common usage or evidence that there has been a legal change of gender, for example, in California, where you can obtain a court order with the same type of almost identical medical letter. This is the same standard that was put in place. This is absent and outside of the DOMA context, but this is the same standard that California uses, is the one that under the Clinton time period of the Department of State, that policy was also put into effect for U.S. passports for U.S. citizens who wanted to get a new passport in the changed gender. All right, but more importantly, that three-part test I was talking about, valid where performed. Well, as of today, we are at a new count. We have 17 countries, once you include Luxembourg, which it's expected to go into effect in 2015, that will be issuing same-sex marriage licenses, or rather, will be able to legally marry individuals regardless of the sex or gender of the spouse. For the United Kingdom, depending on where Scotland stands, or where you consider Scotland to stand, the United Kingdom is counted as one here. We have, added several over the years and months since the last presentation and the first presentation. The states where there are or were validly performed marriages are listed here. We are up to 24. The 4 last ones listed here, or rather I should say 5, Colorado, Arkansas, Wisconsin, Michigan, Utah, these ones have stays now put in place since a federal court or decision has been brought down to strike down that state's marriage ban. For a very brief window, for example, in Utah, in I believe it was January or either January, February, or March, before they were able to put a stay in place in that state, there were about 1,200 or 1,300 same-sex marriages performed and licenses issued. Obama administration went on the record and said, we are recognizing those ones even though the state may not. So even though the state may not even recognize its own marriages there because of that stay that later went into effect, Obama's administration, Eric Holder, has confirmed they will, the U.S. Government, the Immigration Service, will in fact recognize those marriages because they were in fact valid where they were performed. In Colorado, we had a very new development today. Those of you who have been following the subject, there was a quote-unquote rogue person who is issuing these marriage licenses despite the stay, and a federal court today ruled that they do not have to stop doing it. They do not have to stop issuing the licenses. So California is in fact, Colorado is in fact continuing to issue marriage licenses despite the stay, and a federal court today said that they do not have to stop doing so. Whether or not those specific ones will be recognized is a open question, since it was only about 2.5 to 3 hours ago that came out. Nonetheless, because the ones issued before the state went into place are being recognized, it's a very probable and likely conclusion to reach that those will also be recognized. We also have 2 North American capital districts, not countrywide per se, but 2 North American capital districts where those marriages are performed. And Mexico City, even individuals who say live in one of the other states and marry their fiance in Mexico City and go back and live maybe in Monterrey or go back and live in Tijuana, will in fact be able to have that marriage recognized for U.S. immigration purposes. It was valid where performed in the federal district there in Mexico City. And the District of Columbia as well, individuals who say live in one of the states, maybe like Texas, where there is a stay in place or a ban still being adjudicated in the courts, married in the District of Columbia or any of the other states where it is recognized, it will be recognized by the federal government for immigration purposes. So, it looks like we've had a problem here. Where does that come from? Oh, we have some technical difficulties here. Just stand by one moment. Awkward. All right. All right. So back to the presentation. And just as an aside, this is the current list of states where there is a federal challenge under effect. There is a 10th Circuit Court of Appeals case currently pending for the Idaho decision. And it's important to note that in every state where there was or is a ban on same-sex marriage, there is also a court challenge being adjudicated. So that is good news for equality and for moving forward. So this is just for your knowledge. To move quickly through the other ones, no bad faith generally just means not fraudulent and not entered into solely for the purposes of immigration benefits. There are some special considerations that USCIS does and has in the past year taken into account. For example, when one spouse identifies as bisexual as opposed to heterosexual or as homosexual, whether or not and to what extent anyone identifies with one of those three would only be relevant, and even then, barely so, if they had a marriage to a person of a different gender than the current marriage, let's say within the past 6 months, and they filed a green card petition for that person and then withdrew it and then got married to this person of a different gender and filed a green card petition. Those are the kinds of things that would be fraud indicators, but an individual who identifies as bisexual in and of itself is not a fraud indicator, and that is an important point to note. USCIS training materials on point, and they do in fact have training materials for a post-DOMA world, do indicate that they will not, in and of itself, take someone's identity as a bisexual as an indicator of fraud. And then, like I said before, not contrary to public policy in the state where they reside or intend to reside. So, most importantly, and where we are now, what are the options for binational couples and their families? For example, for HR individuals, deciding whether or not to extend offers to people who perhaps need or will get immigration assistance packages, what are the options for this person? What are the options for a same-sex spouse in terms of being able to come on a visa or along with their spouse who's the principal, or to be able to get work authorization while their spouse is here? Well, the answer and the good news is it is the same as for same-gendered couples. Before DOMA, same-sex marriages not being recognized, a same-sex spouse or partner had to obtain what's known as a B2 cohabitating partner visa, which is only eligible for individuals who, for other reasons, are not married or cannot get married, or at least have their marriage recognized. For example, common law marriages in some jurisdictions. They can have their partner or spouse get a B2 cohabitating partner. It's only valid for 6 months. You have to renew it every 6 months or leave and come back every 6 months. You have to maintain a residence abroad. It is a very onerous and expensive challenge for individuals who had to go through it. Now, though, the foreign national spouse will be eligible for the H-4 dependent visa of the principal H-1B, or the L-2 spouse of a L-1A or L-1B, or an E-2 spouse or an E-3 spouse, an O-3 spouse. Great news for highly skilled same-sex same-sex couples coming to the U.S. for temporary work visas. So this kind of lays out the different options. The spouses of F1s and M1s get F2s and M2s. And shortly after the striking down of DOMA and the announcement of the policy of the administration, even SEVP put out a notice that they would be, what the procedure is for school officials, for example, to issue I-20s for the F2 or M2 spouses of students. For other individuals, say, who are unable to get married for whatever reason, because they either live in a jurisdiction where it's not possible and they cannot get to a jurisdiction where it is possible, they will still have to use the B2 cohabitating partner. The other consideration, too, is for Canadians. For a short period of time, there were reports along the northern border that Canadian same-sex spouses applying for entry in one of those dependent categories, H4, L2, were not being granted entry. They were only being granted B2s. And there was talk that CBP, or Customs and Border Protection, said that we didn't have any policy guidance on point. Well, that's just, not, true. The overarching agency within which they operate put out policy, and the other sister organizations were able to put out policy. But since then, since this happened, probably around last fall, we have not had any reports of that occurring. And if anyone listening has had any reports of that occurring, please bring it to our attention as soon as possible. And by us, I mean either me at Wolfstorf or your immigration attorney, assuming that they are an AILA, an American Immigration Lawyers Association member. They can report it up the chain and we can deal with it. All right, so what about immigrant visa options? Well, in the family-based context is what I'm going to talk about next, but briefly before I do, in the employment-based immigrant context, the I-140, whenever you file that, asks you to list the spouse and children of the foreign national who will be or won't be seeking to obtain immigration benefits based on this. Because the marriages are recognized, you are, in fact, supposed to now list and can and should list the spouse on the I-140 unless there's some other reason why you wouldn't. For example, perhaps there's been a death or divorce, obviously. But even if the divorce has not yet gone through, you still have to list that spouse on the form and indicate that either it's in proceedings or something similar. You don't want to ever get into a situation where you withhold information from the government. It's always best to be completely straightforward and open and honest about it. And the good news now is same-sex couples and same-sex, or rather families headed by same-sex couples and spouses are no longer penalized or in any way brought down or lower because of their status. So in the family-based context, this outlines the options. If the foreign national and spouse are currently living abroad and they're living in a country where there is an international USCIS office and they want to move back to the U.S., they are able to file locally with the USCIS International Office. There are only a handful of these international offices in countries that have same-sex marriage at current. Right now, South Africa and the UK are the two that immediately come to mind. If you live in a country that does not have a international USCIS, oh, and Mexico too, but that is a little bit more complicated, and I'll get to that in a minute. If you live in a country that does not have one of these international USCIS offices, but your country does have same-sex marriage, or you were married in a country that does, the only availability to file locally would be if you had some kind of emergent situation or extenuating circumstance that would require expedited processing and therefore local processing of the I-130 directly with the embassy or consulate. Things that would amount to that kind of level would be if you, say, had a emergent fear of harm in your country, or you had to relocate, the U.S. citizen had to relocate to the U.S. on very short notice for work purposes to return. So for many couples who've been living in in exile before DOMA was struck down, maybe they were lucky enough to get a job offer from one of their company's international affiliates. That's great. If they were suddenly relocated back to the U.S. on very short notice, and they were in a jurisdiction that would accept this, exceptional circumstance local filing, there is a procedure for doing so, and I would definitely contact your immigration attorney about that process. It can be onerous, and it has to be done correctly. But nonetheless, there is an option there to proceed. The other reasons by which, for special considerations for individuals who will be processing an immigrant visa from abroad based on marriage to a same-sex spouse, perhaps there is a fear of processing that I-130 petition or immigrant visa at your local embassy or consulate for whatever reason. Well, if let's say, you were married in the Netherlands, but you live in Cameroon, and perhaps you don't necessarily want to process that I-130 immigrant visa through that post because, well, it is illegal and punishable by prison and torture for being gay in Cameroon, and you don't necessarily want to identify as such in the embassy or consulate. Well, you are able to request discretionary third country processing of that I-130. So there are safe options available, is the point that I want to make. You are not limited to filing or processing in a place where you do not feel safe. The same goes for K-1 visas. If you have a fiance who perhaps lives in a jurisdiction that they do not feel safe processing that visa, you are able to request safe country processing there down the road. 1 second, please. Okay, so if you're in the U.S., though, if you are going to go down the I-130 route, or if you live in a jurisdiction that does not have a local office and you do not have a exceptional reason for filing locally, then you do what everybody else does. And this is one of my, most commonly asked question is, wait, how long does this take? Well, it takes about 10 months from start to finish just on this end. You file the I-130 petition just like everyone else in the USCIS Chicago office. The USCIS will process anywhere from 5 to 10 months at current. Once you file the I-130, you can also file a concurrent K-3 petition. The K-3 is basically dead. It's not generally used anymore. But the K3 in theory is a race to the finish. Whichever is approved first allows you to process. And if you get the K3 processed first and you get the K3 visa, you can come into the U.S. and adjust. This is only possible, though, if you got married in the country where you're processing you intended to process the I-130 and the K3. So that would be limited to those countries that were mentioned previously where same-sex marriage is valid where performed. So, for example, if you are going to process in New Zealand and you were married in New Zealand, you have an I-130 either being filed in Chicago or already pending, you can file the K3, and whichever is done first, you can process. But in practice, they take about the same time, and so usually the I-130 is approved before the K3 visa is issued, so it doesn't really work out. So once your I-130 is approved, it's sent to the Department of State's National Visa Center, and the National Visa Center will then make contact. Before, they were taking roughly about 2 to 4 weeks. There's a large backlog. We learned from the Department of State in June that they have a massive backlog that they're working out of, and therefore it's taking a little bit longer to make contact with the foreign national to be able to set up paying all the fees and asking them to submit all the required civil documents for processing. At this time, if there's an individual in the U.S. who needs to file, say, a waiver for any reason, for specifically a waiver of the 3 or 10-year bar, this is the time period where the 601A would be filed. You file with USCIS. You have to demonstrate extreme hardship to a U.S. citizen spouse or parent, and there's a special provision in the 601A context that there's only waivers available for individuals, who there's no other means by which they could be denied. So, for example, if there's a criminal inadmissibility issue in addition to a 3 or 10-year bar issue, then it's likely that the 601A could be denied, and then you have to apply for the waiver from abroad. So let's say the NVC is done processing all your documents and or you're done with that initial waiver process. Then the NVC forwards the application docs to the specific post. The DS-230 Parts 1 and 2 are no longer used. The DS-260 is the standard now. The jurisdiction, as I mentioned before, could be your home country, the one where you last lived or where you're national or from, and then or third country processing. The K1, so then the visa is issued and you get to come to the U.S. just like everybody else. Now, for individuals who are not yet married and they're coming from abroad, the K1 visa process is a consideration. The K1 is a very long and daunting process, and the 13 to 15-month minimum here is very conservative. Or rather, not conservative, but very generous. We've seen some take much longer just because it depends on the very specific post. Some have a large backlog for fiancé visa petitions, whereas some are much speedier. London is actually one of the speedier posts at current, whereas, say, the Philippines or other locations may be longer. The difference between the K1 and K3. The K3 is if you're married already and you have an I-130 petition pending. The K1 is if you're not married. There's also no requirement with the K1 that you process through a country where you got married, because that's obviously not possible. But what about for same-sex marriages in the K1 context? Well, do you have to specify that you're going to get married in a specific jurisdiction in the U.S. that processes or that permits same-sex marriage? I would say yes, that would be wise to do. You want to pretty much do everything you can to make the case as approvable as possible for USCIS. And if there's even a question, even though it's not the right standard of proof, in practice USCIS doesn't always follow their own standards. So you would want to say, yeah, I intend to marry within 90 days of entry my fiance in, Massachusetts or California or Pennsylvania or Oregon. even if you're living in another state. Now, while that's not an explicit statutory or regulatory requirement, it behooves you to do so. The K-1 process also has another kind of stipulation to it, where you have to basically remain outside the U.S. while it's processing, and that can be a daunting problem for many people, being separated and not being able to come into the U.S. even for short visits while the K-1's processing. The reason being is they don't want you to bypass the procedure. Well, there's also a procedure by which you can apply for a special type of visa called a B2 fiancé of a U.S. citizen visa, which you still have to maintain and demonstrate all of your required residences abroad, and you in fact have to remain abroad. But that specific type of visa will allow you to come in while the K-1's pending, but only that specific type of subset visa, and you have to have it annotated with the specific citation to the Department of State regulation that permits this. So you need an immigration attorney probably to help you, unless you are an immigration attorney. The adjustment of status process once you entered in K-1 is, or if you're already in the U.S., say in another status. Let's say you're here as a tourist and then you fall in love and get married, or you're here on an H-1B and you fall in love and get married, or you're here with an entry with inspection and you've been married for a long time, you can adjust status. In the family-based immediate relative context, and this is the same regardless of the sex or gender of your spouse, you do not have to be in non-immigrant status in order to adjust. It is discretionary, absent any factors to the contrary, to say maybe you're a person of bad moral character or whatever. USCIS should improve, and in practice does, approve applications to adjust status to green card holder from within the U.S. You just have to have entered with inspection, and you must not be otherwise inadmissible. So, as long as there's no criminal things that would make you inadmissible, or there's no 3 or 10-year bar issues that were triggered previously, even though you somehow managed to get back into the U.S. through a waive-in or something else. This also requires a joint interview at a local USCIS office, which is different from the I-130 from abroad context, where the foreign national is the only one who will be making their appearance. 1 year and 9 months after the adjustment of status is completed and your spouse becomes a green card holder, you jointly file a 751 with USCIS to remove the conditions, because they give you a 2-year green card at first, and then after the 751 is filed and approved, you get the 10-year card. The reason why you would not need a 751 is if you've been married for more than 2 years before the date you filed the application. So for couples who have been married for a long time and are now just getting to file their adjustment of status, if they've been married for longer than 2 years, then you do not need to deal with that intermediate step of the 751. Marriage to a U.S. citizen also provides another avenue and a faster avenue to becoming a citizen of the U.S. If you are married, or rather, if you've been living in marital union with your spouse for 2 years and 9 months leading up to the 3rd anniversary of becoming a permanent resident based on marriage to a U.S. citizen, then or if you just became a permanent resident and you're married to a U.S. citizen, you're eligible to apply for naturalization. What about for same-sex couples where the instead of a U.S. citizen as one half, there is a permanent resident involved? Well, spouses of permanent residents are in the family-based second preference. Those of you familiar with the employment-based context, it is the EB1, EB2, EB3 categories. In the family-based context, that's F1, F2A, F2B, F3, F4. F2A is the preference category for immediate relatives of permanent residents, including spouses. There was a period last year in post-DOMA, but pre-fall, probably I think it was August, September, maybe October. I think it was September. The F2A category became current, and permanent residents with foreign national spouses were able to file concurrent I-130 and adjustment of status applications, meaning their spouse were able to get employment authorization documents, advanced parole, etc. And that, that was a huge benefit. And those individuals now who have that, even though the F2A category has retrogressed and is no longer current, is backlogged, they are able to remain in the U.S. and work and travel and continue to renew that without having to worry about their underlying status. It's a good idea to continue maintaining both, but they're not required to maintain their underlying status. This just is a quick overview of the waiver process. The 601 versus the 601A. For those individuals, like I mentioned before, who were unable to secure a 601A because maybe they had some other inadmissibility besides the 3 or 10-year bar, after they appear for their immigrant visa interview abroad at the U.S. Embassy or Consulate, the officer will say, sorry, you have to now file a 601. So the 601 is filed with USCIS in the U.S. The same standards apply, except for it is open to all of the other types of waivers, not just the 3 and 10-year bar. Same standard apply. You must have a qualifying relative who would suffer extreme hardship if you were denied entry to the U.S. and if they were forced to relocate out of the U.S. and go live with you in your country abroad. For anecdote purposes, some things that have been shown to be enough hardship, for example, for these things, include on the abroad side, if you had to go live with your spouse in a country where there is a widespread pattern and practice of persecution against LGBT individuals, and in particular LGBT couples or families. It's hard to say that you would, not be the subject of the persecutor's ire whenever you are holding yourself out as married and are married, and especially if you have children that you would have as part of your marriage. Most jurisdictions that have persecution against LGBT individuals, I would, wager that it will also be very, very dangerous if you took your family there with you. So just things to keep in mind. Other types of hardships include things like medical or financial alone is not enough hardship. You have to, it's usually coupled with something else. On the medical side, that can be anything related to either care, availability of care in that foreign country, or inability to receive the care of your loved one if they were forced to leave the U.S. Financial things like, if you have a profession in the U.S. or you have a business in the U.S. or your property in the U.S. that you would have to sell if you left, or you wouldn't be able to practice your profession abroad without significant additional investment. It would basically be financial ruin. For example, if you were an attorney and had to go to, say, Uganda, and where you're not licensed to practice, let alone having to live in fear of arrest and torture for being gay with your gay spouse. Considerations. Then there's also some other types of waivers briefly mentioned here, the 212. If you were previously removed from the U.S., you may have to apply for a 212 to be able to come back in. Individuals who are former J1s who became subject to the 2-year home residency requirement. There's a number of ways that one can be subject to the 2-year home residency requirement. It's not just if you received, say, government funds or were here in a special type of J1. You could have become subject because you were from a country where there's a skills list where to be able to come to the U.S., you have to then go home to that country and practice that profession or teach whatever you learned in the U.S. For 2 years before coming back. The waivers for this are just as numerous, and you can use whichever type works accordingly. If you were a J2 dependent of a J1 who was subject to the 2-year home residency requirement, and you went into the U.S. even for, say, a day or a week as their J2 just to visit them while they were there, you also are now subject to the 2-year home residency requirement and will have to obtain your own waiver of that. But if you were a child under 21 under U.S. immigration law, whenever you were in the U.S. and now you are older than that, you can obtain a government interest waiver from the DOS as the interested government agency. Other types of waivers include the exceptional hardship persecution waiver for individuals who, similar to the extreme hardship you would suffer as, a married gay couple or married lesbian couple in a place where people are persecuted for the same. An exceptional hardship showing a persecution would similarly qualify in the 612 context. Under the asylum laws, like we were talking about persecution, if you fear persecution on account of either a well-founded fear based on a widespread pattern and practice, or because you had suffered past persecution on account of race, religion, nationality, political opinion, or your membership in a social group, in particular, sexual orientation is a particular social group, not at the precedent level, but certainly in practice, transgender individuals, bisexual individuals, HIV-positive individuals have been identified and adjudicated as particular social groups. The asylum one-year deadline still applies. For LGBT individuals, though, there's always been a long-standing exception to the one-year filing deadline if you had any changed or exceptional circumstances. For individuals who, say, maybe hadn't come out of the closet until recently, well, that can be a circumstance that could qualify as an exception to the one-year deadline as long as you can document it. Because if you didn't previously fear persecution in your home country because you are, say, a lesbian or because you are transgender, but now have either come out and self-realized and now realize the harm that could befall you, or similarly have transitioned and similarly realize that the harm that could befall you if you were to go home, that can be an exception to the one-year filing deadline. Just as an aside, though, in the asylum context, there's a massive backlog, especially in Los Angeles, where individuals are waiting years for an interview. They are trying to rectify this, and they are now offering individuals, canceled appointments. They're allowing people in the large backlog to say, I would be willing to appear for an interview. Can we do that? So just one another consideration. So immigration reform, is that happening this year? That's a negative. The crash of immigration reform is unfortunate. Some of the provisions that have been put out in the past are listed here, but since that's not going to happen, we're basically limited to whatever Obama manages to come up with on the executive order level. Hopefully that is something that will be beneficial and positive, and stay tuned for our blogs and webinar updates as we receive them. As of now, there are no guarantees of what that will encompass. Some possibilities would be potentially to expand the eligibility for DACA or the benefits that come with DACA to a wider range of individuals. That may also include removing remove the spouses and children from the count of immigrant visas to remove backlogs for the immigrant categories. So, like we said, there's like in the green card context, there's the EB3 or EB2 work visas, or the F2A, which is currently backlogged. Those lines are not just based on the principal person who has the priority date. It is also based on the number of family members that adjust or get green cards with them who take up those numbers. There's no provision in law or regulation specifically that says they have to be counted in those numbers. They just say that they shall be given the same visa classification as the principal. So by executive order, as the argument goes, and I have to credit Attorney Cyrus Mehta's office for that wonderful blog they put out on this point, that the Obama administration does have the authority and could remove those specific visas from being counted in the overall. This has the potential to incredibly reduce backlogs in all categories and advance the current priority dates significantly, whereas it might even be possible for all categories to finally become current again and end the long wait times that are currently faced by individuals. So this concludes the body of the presentation. I would like to see if we have any questions from the audience. If there are, you can use your chat feature to put out the question, and I will give you an answer. 1 second as I pull up the questions asked so far. All right. So our first question is, could you please repeat the transgender restrictions? Well, there's not necessarily restrictions. For purposes of recognizing a change in gender, there is a memo that was put out by USCIS in order to have the identity document issued in the changed gender. This is usually done by a letter from a doctor certifying that all medically necessary steps have been completed to effectuate the transition. And then other types of documents that can be submitted with that to further show that the change in gender has gone through would be something like a court order, in which in California at least, the doctor's letter is enough for, and or common usage. There's also some other specific points about that memo that I can go through separately. So we have another question. Which processing office is most expedient to complete? Well, processing times across the board in the U.S., just to give you an idea of procedure, once an I-130 petition is filed with the Chicago box, it is initially processed just for completion, and then it will be sent to one of the field offices for actual adjudication. Excuse me, not field office, service centers. There was an overflow issue because of the backlog that occurred after DACA for I-130s, and the Texas and Nebraska Service Centers and National Benefit Center and California and Vermont all chipped in and were able to work through the backlog ostensibly. And it supposedly is supposed to be down to about 5 to 7 months now. Those that were processed the very first ones transferred to one of those offices. The California Service Center, for example, which doesn't traditionally handle those, doesn't usually handle those in the recent times. They may have even been filed, the week before. We've had some that were approved in a few weeks. Those were the lucky few. I would not count on anything faster than 5 to 7 in the U.S. Abroad, for international USCIS offices, London was taking about, I believe, 60 days most recently, and in South Africa, I believe it was. It's been a little while for that one for me. I think it was either, I might be confusing it with another post, but it was either 30 or 90 days for processing there. For the exceptional local filing, those I've seen approved in a few days. The issue there is, though, is getting that exceptional local filing. Next question. Can dual foreign national couples get married in a state that allows same-sex marriage, example California, and then apply for spouse visas? Yes. So there is also a particular subset of B2 called fiance of non-immigrants currently in the U.S. That B2 spouse can come from abroad, or excuse me, that B2 fiance of a non-immigrant, once they have that visa specific with that annotation, can enter the U.S. And for the sole purpose of getting married in the U.S. to the non-immigrant principal, say H-1B or L1, and then after marriage file a change of status to that appropriate visa category, say as L2 or as H4. Similarly, an H-1B can marry an H-1B, and then in the U.S., even in Massachusetts, in Pennsylvania, wherever it can be valid or performed, and then they can, one of them, if they no longer want to work or are reaching the end of their time or for whatever reason, could then file a change of status to H4 if they wanted to. If you are able to secure a K-1 visa for a fiance and wait the 13 to 15 months, does it make the subsequent processes any faster to get a green card? Well, if you're going to do the K-1 visa process and you're willing to wait and able to wait that whole time, you're waiting for the K-1 petition in the U.S. to be approved, so 5 months. Then you're waiting for the K-1 visa to actually be issued. That can be 7 months or more. It can be a little faster sometimes, but it depends. And then once you're in the U.S., you have to then continue and file the adjustment of status. It's not necessarily faster. The processing times for adjustment of status once you're in the U.S. Really depends on the local office processing times. In LA, we've seen in LA downtown district office, we've seen things go as fast as maybe 3 months. It's starting to slow down again. But for example, in places like San Bernardino, which is not too far from here, we've seen much longer wait times until you get the interview. Similarly, in Miami has a large backlog right now for getting an interview. So does Tampa. It really just depends on the local USCIS office in the U.S. at that point. And the K-1 does not necessarily make that go faster. You still have to appear for a interview together at USCIS in the U.S. Is there a best approach to use cross-border Canada-U.S. to enter the U.S. and not as individuals? Well, I'm not sure I understand the question in particular. No, I don't think that there's a difference. Any port of entry into the U.S. Will be the same level of scrutiny CBP applies, be it from a pre-flight in Pearson or at a land border in San Diego or at a seaport in Boston. I think it's all, the same rules apply across the board. Let's see. I have one more question here. Question is about the visa waiver program and whether or not and to what extent a person could enter that way. If a person enters the U.S. In visa waiver status, you're generally permitted to remain for up to 90 days. There's no extensions of that. There's like a very, very rare, absolutely emergent permission to remain process that's very complicated and involved. So for simplicity, it's 90 days, no extensions. There's also a consideration, though, if you're going to try to apply for immigration benefits after that. If you're intent upon entry in any category where dual intent is not permitted, or you have to show that specific primary non-immigrant intent, if your intent really was to get married the whole time, then that's not a permissible usage of the visa waiver program. If your intent was to just come in and visit and then you didn't know, or things happen and you fall in love and then you get married, that's okay in general. You just will may face some questions about that at the USCIS interview. That being said, the B2 visa for fiancés of U.S. citizens or the B2 visa for fiancés of non-immigrants currently in the U.S. Are very specific and are meant to provide relief to individuals who were otherwise, say a person in H-1B can't get leave off of work to go back to Mongolia and have a whole marriage ceremony there and then come back to the U.S., wait for the person to apply for the H-4 there. you know, they could stay at work, and then the fiance can apply for their B2 fiance visa in Mongolia, get it, come to the U.S., get married, change to H4 without the H1B having to take time off of work. All right, that is it. I am absolutely going to circulate these slides. They will be available once they are finalized, which will happen as soon as I press stop on this recording. This is being recorded as well, so if you want to come back and watch anything or listen to anything in particular again, it will be available up on our website. It should just take a moment to process and post. I want to thank all of you for your time and attention and for attending this webinar. If you have any more questions whatsoever, I would like you to look at the number on the screen or look at the email address on the screen. My name again, Joseph Shepard. I'm one of the associate attorneys in our Santa Monica office. We do have offices in New York, and we do have international affiliates as well, and offices through our partner firms in the